Students, welcome to my YouTube channel, Sure Short Questions with Narayan. In today's video, we will discuss about the Code of Civil Procedure, which is in short or popularly known as CPC of 1908. In this video, the discussions will be on the important questions on plaint, pleadings, ex parte order, order and decree, doctrine of subjudice, doctrine of res judicata, temporary injunctions and attachment. This is important for the annual or semester exams of students of LLB, BA LLB, BB LLB, LLM. Also, this is important for CLAT aspirants, ISLET aspirants, and those who are preparing for judiciary exams, UPSC and state PCS exams. So let's start from question number 1. What is CPC? What are the objectives of CPC? The Civil Procedure Code CPC, enacted in 1908, is the primary law governing civil legal proceedings in India. It provides a comprehensive framework for the fair and orderly adjudication of civil disputes. The CPC outlines procedures, rules and guidelines for filing civil suits. It outlines procedures, rules and guidelines for filing civil suits. The conduct of trials, judgment enforcement, appeals and other civil legal proceedings, ensuring a uniform procedure throughout the country. Aim. It aims to ensure justice, efficiency and uniformity in civil cases, guiding litigants and courts through each step of a civil case from filing to appeal in a fair and orderly manner. What are the objectives of Civil Procedure Code, the CPC? The main objectives are uniformity and consistency in procedure. CPC standardizes the civil code procedures across India, creating uniform rules for all civil codes, which promotes consistency and predictability in civil law. Efficient resolution of civil disputes. This is the second objective. By establishing clear procedure for each stage of a civil case, the CPC aims to expedite the resolution of disputes and avoid delays. Third is protection of rights. It ensures that all parties in a civil suit have an equal opportunity to present their case and that justice is administered fairly and transparently. This is equal opportunity is the key word in this objective. Reduction of procedural complexities. The CPC streamlines and simplifies procedural complexities, allowing parties and courts to focus on the substantive aspects of the case rather than on procedural hurdles. Guidance for court. The CPC acts as a guiding framework, helping judges interpret and apply procedural laws consistently while giving room for judicial discretion whenever it is necessary. Finality of litigation. The CPC provides a structured system for appeals and revisions, but it also limits the ability to repeatedly challenge the same issues, helping to prevent endless litigation and promoting finality in judgments. Question number 2. Define the following. What is ex parte order and what is a pleading? Ex parte order, coming to the first part of the question. Ex parte order. Ex parte order is a legal ruling issued when one party to a legal proceeding is absent. Under the Code of Civil Procedure 1908, an ex parte decree may be passed against a defendant who fails to appear in a court even after receiving summons or does not file their written statement within the allotted 30 days period. If the limitation period crosses and WS is not filed, an ex parte decree holds the same legal validity as a bi-party decree. However, the defendant has the right to apply to set aside the ex parte decree if they can prove that they were not served with the summons or they had a valid reason for their absence. To set aside an ex parte order, the defendant must submit an application to the court, including the grounds for dismissal and supporting evidence. The application must be filed within the specified time limit. Pleading. The second part of the question. Pleading is the formal written statement submitted by parties in a legal proceeding outlining their claims, defenses or allegations regarding the case. Pleadings are the foundation of a lawsuit as they clearly present the issues in dispute and set the scope for the court's examination. In civil cases, pleadings typically include plaint, the initial complaint filed by the plaintiff outlining the grounds for the lawsuit, written statement, the response filed by the defendant addressing the claims made in the plaint and presenting any defenses. This is also in short known as WS. Pleadings are crucial for ensuring that each party knows the other's arguments and that the court can determine the matters to be adjudicated. Differentiate between an order and a decree under CPC. Let us discuss about the basis of comparison, decree and order, meaning formal expression of a court's adjudication of the rights of the parties in a suit is decree. Formal expression of a court's decision on any matter in a suit that is not a decree is order. Section 2 of 2 subsection 2 defines decree in CPC. Section 2 subsection 14 of CPC defines order. The nature, decree deals with substantive rights, typically resolving the main issues of the case. Order addresses procedural or incidental matters, not necessarily resolving the main issues. Content. The decree content declares the rights of the parties regarding the main dispute in the suit. In order, it provides directions or rulings on procedural issues without declaring rights. Finality. In the case of a decree, it closes a suit through final or partly final decrees. May or may not close the proceedings of the suit. That is finality. If we come to the types of pleadings, types of decrees and order, it can be preliminary, final, or partly preliminary and partly final. In the case of order, it can be interlocutory, that is a temporary order or a final order. Appealability. It is appealable and an aggrieved party has a right to appeal. In the case of order, only specific orders listed in the CPC are appealable, others are not. Examples of decree: judgment for possession, injunctions, money decrees. Examples of order are orders for issue of summons, adjournment, temporary injunctions, attachment of property. These are examples of orders. Question number 4. Explain the features of Code of Civil Procedure. The principal features of the Code of Civil Procedure are jurisdiction of courts. First of all, if the court has the power to decide the matter, it clearly defines the jurisdiction of civil courts to ensure that cases are heard by the appropriate courts based on subject matter and value. This is the key word you must remember. Subject matter and value decides the jurisdiction of courts. The CPC outlines territorial and pecuniary jurisdiction of district and high courts, ensuring that cases are assigned to appropriate courts. Pleadings. The CPC outlines detailed rules for pleadings, their format and content required for plaints and written statements. Summons and service. The Code of Civil Procedure establishes procedures for issuing summons and serving documents to ensure that all parties are properly notified of legal actions. It includes personal delivery, register mail, and publication in newspapers for parties whose whereabouts are unknown. Even these days, WhatsApp serving of summons is also accepted at situations. Trial procedure. The CPC has detailed and uniform rules for conducting trials, examination of witness, submission of evidence. Interim orders. It allows for the granting of interim relief and temporary injunctions to protect the interest of parties pending the final decision of a case. Appeals. The CPC outlines the process for appeals against judgments, allowing parties to seek redress if they believe a decision is incorrect. Execution of decrees. It is outlined mechanisms for the enforcement of court orders and decrees, ensuring that judgments are effectively implemented. Amendment of pleadings. The CPC has the provision to amend pleadings, allowing parties to correct errors or add necessary details. Next question. Explain the following: doctrine of subjudice, doctrine of res judicata. Coming to the part A of the question, doctrine of subjudice. The doctrine of subjudice is a legal principle under the CPC which prevents courts from simultaneously trying two cases on the same matter between the same party. These are the keywords you must remember. Simultaneously trying two cases which involves same matter between the same parties. Got it? Subjudice means under judgment, and this doctrine is meant to avoid conflicting decisions, reduce multiple cases on the same matter of dispute. Purpose of the doctrine. The purpose of the doctrine of subjudice is to avoid the inconvenience and inefficiency of having two courts decide the same issue, which could lead to contradictory judgments. It aims to protect the interest of the parties and maintain judicial harmony. Section 10 of CPC deals with the doctrine of subjudice, which states that no court shall proceed with the trial of any suit in which the matter in issue is also directly and substantially in issue in a previously instituted suit between the same parties and is pending in the same or any other competent court. Essentials of the doctrine of subjudice. The matter has to be identical. The subject matter of the two cases must be the same, meaning it should be directly and substantially in issue in both the cases. Same parties. The cases must involve the same parties or their representatives. Prior suit. There must be a previously instituted suit that is still pending before a competent court. Competent court. The previously instituted suit must be in a court that has the jurisdiction to adjudicate it. Stay of proceedings. When the doctrine applies, the court will halt the proceedings of the latter case until the previously instituted case is resolved. Exceptions. The doctrine of subjudice does not apply to appeals. Section 10 does not restrict the hearing of an appeal if one of the cases is at the appellate stage. Interim orders. The doctrine does not affect the court's power to grant interim relief. Coming to the second part of the question, doctrine of res judicata. The doctrine of res judicata is a legal principle that prevents the same dispute from being litigated more than once. This is the key word, same dispute to be litigated more than once between the same parties. The term res judicata is Latin for a matter of already adjudged. A matter already judged means a case which is already decided. The doctrine is codified in section 11 of CPC. Applicability. It applies when a final judgment on a matter has already been given by a competent court, ensuring that parties cannot re-argue the same issues in court. What are the essentials of the doctrine of res judicata? Final decision. There must be a final and valid judgment or order in the previous case. Same parties. The parties in both suits must be the same or acting in the same capacity as they were in the previous case. Same subject matter. The issue in the second suit must be directly related to the matter already decided in the first suit. Competent court. The previous decision must have been made by a court with the proper jurisdiction to decide on the matter. What is the scope of res judicata? It applies to civil, criminal and constitutional matters. It applies to all kinds of judgments including consent decrees and covers matters that were decided or could have been decided in the first proceeding. Still, there are exceptions to it. Fraud or collusion. Res judicata does not apply if the previous decision was obtained through fraud or collusion. Lack of jurisdiction. If the either judgment was by a court lacking jurisdiction, it cannot bar subsequent suits. Violation of principle of natural justice. If a party was not given a fair opportunity to be heard, res judicata may not apply. These are the exceptions. Next question. What is the purpose of temporary injunctions under the CPC? Temporary injunctions are essential tools for courts to ensure that justice is not frustrated and that the parties' rights are preserved until a final decision is reached. The purpose of temporary injunction is to provide immediate relief by maintaining the status quo between the parties during the pendency of a civil suit. This prevents any irreversible damage or change in circumstances that could undermine the final outcome of the case. Temporary injunctions are covered under Order 39, Rule 125 of the CPC. Purpose of temporary injunctions are preventing irreparable harm. They help to prevent irreparable injury or harm to the applicant that could not be compensated by monetary relief if the defendant's acts before the suit is resolved. Maintaining status quo. The temporary injunctions keep the situation unchanged, ensuring that neither party makes alterations that would affect the court's final decision. Avoiding multiplicity of proceedings. By addressing potential disputes immediately, temporary injunctions reduce the likelihood of further litigation and maintain judicial economy. Balancing interest. Courts use injunctions to balance the competing interest of both parties, protecting the applicant's rights without causing undue hardship to the opposing party. What is a plaint in CPC? What are the essential elements of it? A plaint is the formal written document submitted by the plaintiff to initiate a civil lawsuit under CPC. It is essentially a complaint in which the plaintiff outlines the facts, claims, and relief sought against the defendant. The plaint forms the basis of the lawsuit and sets the case in motion for adjudication. What are the essentials of a plaint? Title and jurisdiction. The plaint should specify the name of the court where it is filed. It must mention why the court has the jurisdiction to hear the case, considering territorial and pecuniary limits. Parties information. Name and address of the plaintiff defendant. The plaint must provide the full name, description, and residential address of the plaintiff and the defendant. Capacity of the parties. If any party is under a disability, such as being a minor or mentally incapacitated, this must be mentioned along with the plaintiff's authority to represent them. Cause of action. The plaint should clearly outline the cause of action, which is the set of facts that give the plaintiff the right to sue. This is a vital part of the plaint as it explains why the case is being brought before the court. Facts of the case. The facts should be presented chronologically, logically, and without unnecessary details. The plaint must include only material facts directly relevant to the cause of action. Relief sought. The plaintiff must specify the relief being sought from the court, such as damages, injunctions, or specific performance of a contract. This is done in the prior cause of the suit. Valuation of suit and court fees. The plaintiff must specify the monetary value of the claim, if applicable, and the corresponding court fees paid. This helps the court verify if it has the appropriate pecuniary jurisdiction. Different states in India have different court fees according to their rules and the law, minor acts. So this differs from state to state, the court fees. Verification. The plaintiff must include a verification clause where the plaintiff affirms and affirms the truthfulness of the facts stated in the plaint. This verification must be signed by the plaintiff or an authorized representative. Normally this is done before a oath commissioner who sit in the court complex. Signature and date. The plaint must be signed by the plaintiff or their authorized agent and dated. This formalizes the document and authenticates its contents. Question number 9. Explain attachment under the CPC. Attachment under CPC is the legal process by which a court seizes or restrains a party's property to ensure the fulfillment of a judgment or prevent the disposal or transfer of assets before a final decision. For example, if there is a dispute over a house between two parties, then the court may restrain the second party or the person in whose possession the house is not to sell it before that dispute is resolved. It is a provisional remedy intended to protect the interest of the plaintiff by securing assets that may be used to satisfy a judgment. Purpose. Attachment serves as a protective measure to ensure that justice is not undermined and that assets are available for satisfying a potential judgment. It deters the defendant from fraudulently disposing of assets and preserves the plaintiff's right to recover a decree amount if awarded. Types of attachment. One is attachment before judgment. It is order 38. This is the pre-judgment attachment where the court restrains the defendant's assets to secure the plaintiff's claim. It is typically ordered when there is a risk of the defendant concealing or disposing of the property to avoid legal obligations. Attachment in execution of a decree. It is order 21. After a judgment is passed in favor of the plaintiff, attachment may be ordered to execute or enforce the decree, allowing the plaintiff to recover the judgment amount. Procedure. The plaintiff must file an application in the court specifying the grounds for attachment. The court may issue a notice to the defendant to appear and show cause why attachment should not be made. Upon satisfying that the defendant's actions may jeopardize the plaintiff's claim, the court can order the attachment of the defendant's property. Exemptions from attachment. Some properties cannot be attached, such as personal necessities, tools of trade, wages and pension. Pension, wages, tools and trade and personal necessities are not subject matter of attachment. You must remember it for your competitive exams like judiciary, LLM entrance, UPSC and state PCS exams. Release of attachment. The attachment can be released if the defendant provides sufficient security, pays the claim or proves that the property was wrongfully attached. Question number 10, which is the last question of this video. Discuss the hierarchy of courts under CPC 1908. The hierarchy of courts under the CPC in India is structured to ensure an organized judicial system for civil cases. Objective of making the hierarchy is to facilitate a systematic approach to civil litigation, ensuring that cases are adjudicated based on their complexity and monetary value. The top-down hierarchy in India are the Supreme Court of India, the highest court in the country. It has appellate jurisdiction over all lower courts and can hear appeals against the decision of the high courts and other authorities. The Supreme Court serves as the final appellate authority. High courts. Each state or union territory or two or more states has a high court, which is the highest court at the state level. High courts have the authority to hear appeals from the subordinate courts. For example, why we say two or more states like Punjab and Haryana have a single high court. Likewise, in Northeast, there is a single high court for many small states. High courts can exercise original jurisdiction, especially in writ matters. District courts. District courts are established at the district level by the state governments. They have jurisdiction over civil cases and can hear appeals from lower courts such as municipal court or civil judge courts. Subordinate courts coming under number 4. These include civil judge junior division. They handles cases with a lower monetary limit. Civil judge senior division handles cases with a higher monetary limit. Municipal courts typically deal with small civil disputes. In few states, there are local courts. They may exist in certain areas and handle minor civil disputes. Their jurisdiction and powers can vary from state to state. This is the end of this video that containing important questions for your exams and competitive exams of CPC 1908. I hope you found it useful and exciting. Please subscribe to my channel and hit the bell icon to get latest videos updated on subjects. Like it and share it. Your comment on the video and what you want me to prepare is vital for upcoming videos. Do comment. I wish you good luck. Do well in your exams. Do well in life. Thank you for watching me. Thank you.